This is SSN
Story Studio Network.
Welcome to the Biz Doctor podcast, my love letter to business owners the world over. I'm your host, Lauren Goldstein, award-winning business consultant and advisor who's fondly nicknamed the Business Doctor by my clients. My clients call me the Business Doctor because I help business owners who are burning the candle at both ends diagnose what is actually keeping them stuck in and buried under the day-to-day of their business, and then formulate a business treatment plan to help them adjust their business and team to fit them. And most importantly, support them in having what I call true entrepreneurial freedom. If you're ready to look at your business in a different lens and elevate yourself out of the business operator in the trenches 24/7 to visionary business owner and leader who can take a breath, vacation, and have more fun making an impact with your business, then grab your favorite beverage and your earbuds, and let's dive into our latest episode. Have you ever wondered if you should really spend that upfront money to draft an ironclad employment contract, or if copy-paste from some pages on Google will suffice? Or if you're actually doing all the correct things when it comes to hiring? Well, as someone who's asked these very questions once or twice early on in my business, I can tell you that having an ironclad employment contract is the best investment for your business, and making sure you have all your T's crossed and I's dotted is the very topic of today's episode. I have a juicy story to back it up that I'll share later in the episode, so stick around. Oh, and if you're rolling your eyes or prepping to skip this episode because we're talking about something boring like legal stuff, don't. This will be well worth your time, and Jenny makes the subject, dare I say, fun and easy to understand so you can protect your business and create a win-win for your business and your team. Welcome back to the Biz Doctor podcast. I'm your host, Lauren Goldstein, and joining me in the studio today is employment law expert and attorney Jenny Young, who actually happens to be my attorney too. If you have a team and are thinking about hiring, this is going to be a gold mine of an episode to help you avoid several critical pitfalls business owners fall into when it comes to hiring that could cost your business big. Before diving into today's power-packed episode, let me properly introduce you to my guest here in studio. Jenny Young is a partner at Vela Wood, where she leads the firm's employment law division. In her practice, Jenny advises and represents both employees and employers in a multitude of employment-related areas ranging from complex M&A transactions to general employment operations. Jenny received her JD from the University of Texas School of Law in Austin, Texas. Bottom line, Jenny is going to help us demystify employment law so we can better protect our businesses. Welcome to the show, Jenny.
Thank you. Thank you for having me. Very happy to be here.
I'm so excited about today's episode because it's just, I have seen firsthand how powerful this is. So before we dive into that though, I would love for you to share a little bit more about your story, how you got into this type of law, and the impactful work you do with business owners so our listeners can get to know you and your firm, Vela Wood, a bit better.
Absolutely. So I graduated from undergrad, actually from law school in 2008, and started with a full service law firm here in Austin. I didn't have any idea what type of law I wanted to do, and they were so kind to allow me the opportunity to try different departments. And one of the first areas that I worked in was employment law litigation, and I found it much more exciting and interesting than I ever expected. Shortly thereafter, I was pulled into a different type of litigation and had to step away from employment law for a bit, which was slightly upsetting for me. But, you have to do what you have to do to keep that job. Many years later, about 8 years later, I realized that I just was really unhappy with the practice that I was in. And I assumed that that meant that I really disliked being an attorney. I decided to go take a year abroad and just leave Austin. I had no real plans. Didn't know how I was going to make money, but I had to get out of here.
Love that.
It was great. But at that time, two law school friends of mine that had been working together at a firm that was originally called Vela Keller and had recently been changed to Vela Wood they asked me if I was interested in doing contract work for them, specifically employment law. My first thought was, I haven't touched this in so long. And this firm, the firm that I currently work at, was a business law firm that focused a lot on startup work, venture, mergers and acquisitions, things that I didn't really have a lot of understanding or background in. But I said yes, and it was the best decision I ever made. I've now been here for 8 years practicing only employment law. And it has been such a wonderful growth period for me to learn so much about startups, venture, and how businesses work. And now I can provide really salient and helpful advice to friends of mine like you who have their own businesses. And it's been a joy. I really enjoy helping both employers and employees.
I love that so much. And I think for me, because gosh, we've been friends for 6 years now, I want to say something crazy like that. And I got to get my legal house in order with my business and other businesses too that I'm an owner in. And I think what I love so much about how you work and how you look at the law is you're always looking for a win-win and really looking for how can you support us as the business owners to make sure we're protecting our biggest asset, which is our business, but also being fair to the people that work for us.
Absolutely.
And I love your approach to the law.
Yeah, I think we're really lucky to have clients like you who care about the individuals that work for you. And like you said, there's a balance to be struck between what's best for the business and also being a good employer. And I think we help, people find that balance, and you can feel really happy about A, I'm protected, but B, I'm being fair and kind to people who are working for my company, which is really important.
And something that you helped me really understand early on in my business was the difference between an employee and an independent contractor, because I know I can see, if you can't see us, but I can see her and she's kind of giggling. But I know that when I was first talking about this, it seemed like I could employ somebody like an independent contractor and kind of skirt the responsibilities and the taxes and all the paperwork that comes with having an employee. And you were like, no, you can't. So let's start there, because I think this is such an interesting and complex, nuanced delineation between when you can say somebody is an employer and when somebody is an independent contractor that I don't think a lot of business owners understand.
100%. I think it's one of the most important bits of information that I provide to my clients, from startups all the way to, mid-sized to large companies. I'm often surprised at the size of a company that can still be uncertain about what this even means. And it's an important thing to consider when you're starting your business, because you're usually tight on cash, right? And so the very first idea is, of course, I would only engage contractors. Why would I hire an employee? I don't have enough money. A lot of business owners think that means they have to provide health insurance, workers' comp, and it can be a little scary. So it seems natural to engage with someone as a contractor, because as a contractor, you have a much lower level of protection from federal and state governments than you do if you're an employee. As an employee, you are protected by laws that say that you can't be discriminated against, you can't be retaliated against. They protect you from harassment. They mandate that you're paid at least a minimum wage for every hour you work, unless you're an exempt employee. And so those types of protections are provided only to employees. And that's kind of the difference between an employee and contractor when you're initially thinking, well, what do I do? How do I classify these people? The thing that most business owners don't know is that the determination of whether someone is a contractor or an employee is solely determined based on law. It is not a decision that can be made between, the employer and the worker. even if the worker agrees to it, even if the worker wants to be a contractor, that will not protect you. Signing a contractor agreement will not protect you if you get into the crosshairs of the Department of Labor or whatever applicable state regulator. In Texas, it's the Texas Workforce Commission, and even the IRS.
Wow.
So penalties are very high, and they can actually bankrupt a company depending on how many misclassified contractors you have.
Wow.
And we'll get into those details. The first thing that you need to consider when you're thinking about bringing someone as a contractor is what state do they work in? Whatever state the worker physically lives and works in is typically the state whose law is going to prevail. Let's go with Texas, since we're both here located in Austin, Texas, and we're pretty familiar with the Texas Workforce Commission. So again, there's Department of Labor level of contractor versus employee test, but it's safe, especially in Texas, to go by the Texas Workforce Commission's test. It's a 20-point test. It's very detailed. And if you can get through that test and determine that your worker is appropriately classified as a contractor, it is highly likely that you will also pass the Department of Labor's federal test. Now, what are some of the major points to consider? The Texas Workforce Commission typically thinks of a contractor as someone who has their own business, not just an individual who does work for other companies on their own, but someone who has their own business. That it would be really great if that person has formed an LLC or even a sole proprietorship, but operating under like a business name. It's always best to engage with that company specifically and not the individual if possible. So that's the first thing to consider. Do they have their own business? Do they provide services, a specialty that my business does not provide as a means to an end? So in other words, I'll give an example. You've got Acme Company, and they have an online business where they sell apparel and t-shirts. Acme Company wants to hire on a salesperson, but they're too small. They don't have a lot of money. So they say, oh, well, let's just get a contractor. We'll give him or her commissions for getting, sales and bringing people to the website. And that'll be, that's perfect. A little contractor role to the side. The problem is that Acme Company, as a business, they sell clothing and apparel. And they're asking this individual to come sell clothing and apparel for the company. That is an intricate part of what the company does. And there's other elements to consider, but that right there is one of the first things that the Workforce Commission will ask you is the role that this contractor or worker is doing something that the company needs to be done in order to even operate. So a better example of someone who would be a great contractor to engage with would be if Acme said, oh, our website needs some work. It's just, it looks old. We're not pulling in a lot of, clientele because it just looks out of date. We need someone to make this more user-friendly and just aesthetically beautiful. They go and they find Mike Engineer, and he's got his own company, Amazing Websites, LLC. And they engage with Mike and say, this is a task. You have a specialty. We would like for you to, overhaul our website, make it look better. This is our general end goal. And here's some parameters. Go do it. And Mike says, sounds good. This is my fee. You pay a deposit up front and you pay the final amount when you're done and satisfied. You have 2 or 3 times where you can ask for revisions, and then we're concluded. If I stop working and I breach this contract, maybe you don't have to pay me the full amount. But I'm going to do this on my own time, at my own place, with my own materials. You're not including me in any type of benefits, insurance. You're not asking me to come to company parties. I am doing this 3-month engagement with you. No one tells me how to do it. They tell me what they would like. And maybe Mike checks in 2 or 3 times during that time period to say, how's this looking? And they say, thumbs up on this. This could look better. Thumbs down on that. At the end, Mike gives them the final product. They are so happy with their website. They pay him his final payment. The engagement is over. That is a very classic example of a perfect contractor relationship. But you don't see a lot of that, again, at the startup phase. And so that's overall, I would say what they're looking for is the level of control. If the company has a lot of control, and if they're like providing resources, right, that belong to the company, or they're paying, at times you can pay for travel, but if you're paying basically for this person to do this work, that should all be something that that contractor factors into their own business costs. Secondly, how do you pay them and how long is the engagement? Because at-will employees are on an open-ended engagement with you, and you pay them on a regular basis. And if you have that same exact situation worked out with a contractor, I'm doing air quotes for the people listening, that looks problematic. That does not look like a situation in which you have hired on someone for an engagement to do something specific that they have an expertise in. They'll also look at how reliant is this contractor on your business for their income and livelihood. If they're only working for your company, and some people even put language into their agreements that say you can't work for other companies while you're working for me. Some go as far and say you can't work for companies like mine after you leave. Now, that's not always an immediate, if that is a part of the agreement, that won't immediately make it, an employment arrangement, but it doesn't look great. I think the frustrating thing for business owners with trying to figure this out is that there's no very clear outline for if 1, 2, and 3, then 4, right? It's, well, if you have 1 and you also have 5, and then maybe you have 2, it might turn out that we think this is actually an employment arrangement. It's very hard to navigate. And that's why it can be really helpful to engage the services of an employment attorney. I know not everybody has those funds in the beginning, but when you're at a point that you have the funds to engage an attorney, and you're looking at bringing on a couple of contractors, especially where you're getting into a place where there could be multiple people that have been considered misclassified, you really want to, of course, look at the Texas Workforce Commission's, test, which is online. And you can look at that yourself, but enlist the help of someone who understands which points in that test are weighed heavier than others. And it's a totality of the circumstances. They look at everything involved in that engagement to determine whether or not you have possibly misclassified someone.
Wow. Do y'all see why I love her so much? Because it would take me years to even scratch the surface of what and making sure my business isn't getting in trouble for things. I love that. That was a great explanation. And I have I have a little story that one of my friends who owns a practice here in Austin shared with me, where I think when you really think about the pros and cons of an employee versus a contractor, the contractor might seem sexy and easy up front, but I think it actually can create a lot of chaos. And so in this particular example, it's a relatively new practice. He brought on a new practitioner and he brought them on as a contractor. But then what happened, this is a cautionary tale, is because he didn't have an employment agreement, she actually decided that she'd learned enough from him and then decided to start her own practice. And then took a lot of the patients that she had, fostered this relationship with her. So it actually ended up kind of biting him in the butt to not have this again, ironclad employment agreement about you're working for me. These patients belong to the practice. You cannot take them with you. And so I think it was a very costly mistake that he had somebody like you to really think through what's the biggest benefit to the practice, what's the benefit to the practitioner. Then he probably could have saved himself a lot of headache.
Oh, absolutely. And I'm glad you brought that up. And we'll talk in a little bit more detail later on about the types of documentation that you want to have with your workers. But as a concept of law, an employee that is working for a company has no right and ownership to any intellectual property that they might be involved in, that they might create, any inventions, any even ideas that relate to the company and the business of the company. You're protected as an employer just by having them as your employee. Whereas a contractor, it's not that simple. It depends on what you agree to in the agreement, in the document, what belongs to who and when. And so, yes, you're right. It can get very complicated, especially if you're just downloading a contractor agreement off of, the internet, which I know a lot of people do, again, to save and cut costs. But those typically don't have the appropriate language that you need to very clearly protect your company's interests, your confidential information, your intellectual property, all of these things that are very important, especially if you have the goal of one day receiving investment dollars and or selling your company. One of the first things that you're going to be asked during due diligence is does the company have control and ownership of all of its IP and confidential information? And if you've got people out there that worked for you as a contractor and never signed an agreement and you're not sure, this can lower the valuation of your business all the way to the point of them deciding it's not worth us purchasing because we don't know for sure that we have the right, to use, or the exclusive right to use all of this information, which is part of the reason we want to even purchase this company. So it's a very important concept for someone who's got that in mind in the future. Like, I want to scale and I want to sell.
Wow. I had no idea. That's the ultimate chess game, right? Of selling and exiting and making sure that you've really set yourself up to have full ownership for sure.
Exactly. And I'll piggyback on that if that's okay.
Yeah.
Because we haven't yet talked about what the real damage is of misclassifying a worker. And this will play a part also in the valuation of your company, if that's your goal. So if the Texas Workforce Commission finds that you have misclassified someone as a contractor and not an employee, there's multiple ways that they will fine you. First, they will look back, and sometimes this doesn't matter depending on how much you did pay the contractor overall, but they'll look to see what minimum wage should have been for every hour that they assume the worker, because most people who have contractors are not asking their contractors to keep track of their time. Mm-hmm. So the Workforce Commission will almost always err on the side of a greater amount of time worked. So they will calculate what minimum wage would have been for all of those hours. And then if there's any reason to support or any evidence to support overtime, that someone worked more than 40 hours in a week, then they will assess overtime fees, time and a half in Texas, some states much higher, for every, hour over 40 hours in a week that they believe this worker worked. In addition, if they believe that you classified them as a contractor in bad faith, meaning you had a reason to believe that that wasn't appropriate, then they will double the amount of damages right off the bat. Holy smokes. Exactly.
Oh boy.
Then it keeps going.
Oh no, there's more.
There's more. They will fine you an interest penalty for every pay period that you were late and not paying this employee. So every 2 weeks there's a fee for that. There's also the cost of unemployment tax that you should have paid to the state, all the way back as far as it will go.
Oh my gosh.
And then interest on that because you were late paying your unemployment taxes. So this can, as I said, I've seen it can bankrupt a company. This can get so expensive so fast. It's not a minor penalty. It's not a minor fee. And the Texas Workforce Commission, like a lot of states, has an agreement with the Internal Revenue.
Oh boy.
Where they're allowed, it doesn't happen often, but they are allowed to then report the company to the IRS. So the IRS then comes after you for all of the payroll taxes that you failed to pay. So,
oh my gosh.
It could bankrupt you or just put you in a very, very negative financial place trying to fix this. Once the penalties are levied against you, they can also put a lien on your business, a public lien on your business, which is embarrassing.
Yeah.
But if we're, again, that business owner who's thinking about scaling and selling, that is something that you would have to disclose in due diligence as well. We have all this potential liability that's hanging around out there for pay, like back pay and fees and back taxes. And that if they still want to move forward with buying your company, they are going to deduct what they think the highest potential liability is from their purchase offer price. So you're really putting yourself at a major disadvantage.
Wow. I had no idea. I'm stress sweating just thinking about that. Wow. I mean, like, this is why I was so excited to record this podcast episode, is because, like, I don't think most business owners know this. And
they don't. And there's really no reason that they should. It's employment law is, in my opinion, there's not a very easily accessible resource that clearly explains these risks and requirements. The TWC has a decently comprehensive website and a PDF that you can download that's called Especially for Texas Employers. And it outlines some of what I'm discussing, not to the degree that I have laid it out. But other than that, if you don't know where to look for it, you don't even know where to begin.
Yeah. And
I mean, I wouldn't know this information, but for practicing this type of law. I also get a lot of pushback with clients that this is the first time they heard it, and it's a real damper on what they were planning. And, you know, they say, well, I've been a contractor before, or this is how everybody in the industry does it. And my response is, I'm sure it is. It's still wrong. And if you get caught, then you'll have to be the example.
Yeah.
I think listeners might be wondering, well, how would I get caught? So I'd like to quickly outline how that happens. What often happens is a contractor at some point files for unemployment. So a lot of times contractors don't understand that unemployment is not a benefit that they receive. So say they worked for you and then they worked for another company and they got fired or whatever, and they list out their last few employers, air quotes again, and they put your company down. Well, then the Texas Workforce Commission goes into their system and looks at the unemployment taxes that have been paid on behalf of that employee. And they say, why is there zero employment dollars paid for, you know, Mike the engineer? And they come to, you know, your company and they say, excuse me, sir, we don't see any dollars in here for this man. And he says that he wants unemployment. Please explain. And the company says, he was a contractor. And then they go, prove it.
Oh,
and
boy.
That's how it starts. Exactly. And that's the most typical way. Other than that, there can be random audits where the Texas Workforce Commission will say, this year we're auditing every beauty salon in Austin, Texas. And they just reach out to you randomly and say, send us a list of all of your workers, contractors, and employees. And then they start asking you the questions and say, oh, actually, we think these have all been misclassified and now you owe this much money to fix it.
Whew.
Yeah. And then the last way is a contractor who leaves and they're just really mad at you. And then they file a wage claim with the Workforce Commission and say, I should have been classified as an employee, but they wrongfully classified me as a contractor and they owe me X, Y, and Z. So those are the three main ways that something like this even comes about. And so I let, especially startup clients who are like, I can't afford this. I have to have contractors. What do I do?
Yeah.
I make sure they at least know what their risk is and what they're gambling. And then again, the chances that this happens, you know, these are the ways that you could get caught, and you have to roll the dice and see what makes the most sense to you when you're really low on funds.
Mm-hmm.
And because we work with startups a lot, we understand that that's something that has to be considered. But I'm a very risk-averse attorney, so I'm very often like, find the money somewhere. You've got it.
Yep.
You can do it.
And hang in there, guys. I'm going to tell you a story that you will just, it's just going to make your jaw drop, but it's going to prove this point of find the money, because it's kind of like having insurance for your house. You hope you never use it, but God, are you so happy that if something happens, you did actually pay those premiums. Before we actually talk more about, compensation and pay and reducing things to writing, I do want to talk about something that got brought up in an interview I was doing yesterday, which is exempt and non-exempt employees. This is something that is a little bit new to me, that I was actually has so many layers. So I'd love for you to tell everybody a little bit more about that.
Absolutely. Yet another landmine.
Right?
That employers are like, what are you talking about?
Yeah, exactly.
So the Fair Labor Standards Act, which is, I'm sure a lot of people have heard of the FLSA. Basically, this federal law applies to almost every company. I'm not going to go into the details of it, but just assume it applies to your company.
Mm-hmm.
This law basically says that if someone is an employee, they must be paid at least minimum wage for every single hour they work, and then time and a half for any hour they work over 40 hours in a week. That is the federal law. Now, states also can create their own specific employment laws. If the state's employment law requires a higher level of protection for an employee, then that will rule. If their law requires a lower level of protection, then the federal law will rule. So in Texas has created the Texas Payday Act, but they also follow the FLSA for some elements of that. Non-exempt and exempt falls under the FLSA, and basically what that means is if an employee is considered exempt, then they're exempt from the laws of overtime and, in some cases, minimum wage. Many of my clients incorrectly believe that exempt solely means someone's paid on salary, and that is not the case. In order to properly classify an employee, there's all sorts of classifications going on here, but to classify your employee as exempt or non-exempt, there are very clear and specific laws that you can actually easily Google in the FLSA and look for exemptions, and they have PDFs that really go into detail on how to do this. But it's based on not just the salary, but it's also based on the employee's duties. So the most common ones are the executive exemption, the administrative exemption, the professional exemption, and I often use the computer employee exemption a lot because that applies to people that are like engineers, doing that type of computer work, not just typing on a computer. Right. Oh, I've had clients try. They try.
I mean,
because
we're crafty. We're crafty.
Yeah, then you don't have to worry about overtime, and you can require this person to work as much as needed, and but that also comes with things like you can't deduct certain amounts if someone doesn't come to work like one day in a week. But that's not important for today. For today. Generally, the exemptions require that an employee is paid on a salary basis, and there's typically a threshold of at least, right now, it's around $36,000 a year. And then from there, they say, okay, so you've hit that first salary threshold. Now, does the employee do X, Y, and Z? Do they fall under this exemption because they perform these administrative tasks for the company in this particular way? It's very specific. The executive exemption would be for, like a C-level or a vice president who is in charge of a specific area in the company. They manage employees. They make at least $36,000 a year. And I think those are the main components of like that exemption, just to throw out some ideas. The computer employee exemption is one of the few that doesn't require a base salary, but requires at least a base hourly range. I can't say off the top of my head what that amount is. I believe it's somewhere in the 20s, like $20-something an hour. But they can also be exempted under that. And so again, it's easier for an employer if they have exempt employees because they don't have to have people clocking in and out. They don't have to calculate. However, if you face the same level of misclassification issues, right? Minus the major unemployment tax issue, because you're clearly still paying your taxes because they're an employee, but you're going to get fined for the minimum wage and the overtime issue. One little thing I'll throw in there to make it even worse is that states like California, my favorite, California, they have the most employee-friendly and employee, employee protections laws than any other state. And California has their own exemption laws.
Oh boy.
That are a higher threshold than even the federal level. So what happens a lot is my clients call me and say, I need a template. I need a template employment agreement or a template contractor agreement. And I always say, well, doesn't really work that way.
Shucks.
You got to tell me what states you plan on hiring in, and then I can make sure the template applies to that state. But if you go willy-nilly hiring people in a bunch of other states we haven't, narrowed this to, you can get yourself into a lot of trouble. So while the contractor and employee classification, I think, is of higher importance, the exempt and non-exempt classification is right there behind it, with needing to understand and properly classify.
Gosh, you weren't kidding. Another landmine.
They're everywhere.
They're everywhere. But that's a really good segue into, we've talked about minimum wage. We've talked about, how the different classifications are. But something that you're pretty adamant about is reducing all of this to writing. So tell me what that means.
Absolutely. So again, many employment laws require that employees be provided with at least very clear explanation of how much they're getting paid and how often they're getting paid. Some states even require that you say exactly how they'll get paid or where they'll get paid, which is kind of an old school thing, right? You don't really pick up your check at the office anymore.
Maybe
some of these laws have not been updated.
Towns.
Yeah, exactly. Let's put it out there for the small towns. But this is so important because, again, when an employee or a former employee makes a wage claim against the company, the regulatory agency that's looking into this claim is going to ask you first and foremost, what agreements do you have? What's in writing? What has been agreed to in writing with this employee? And if the company cannot produce that, that is going to be basically used against the company, because the way these regulatory agencies think is the company has more resources, they have more money, they've got the bargaining power, they have the ability to actually be the ones to make, the details of the agreement and draft it up and have the employee sign it. So the employee is at a disadvantage. So it's then the employer's responsibility to be able to prove that they did everything right. It's a little bit backwards than I think some people would expect, right? You would expect that if someone makes a claim that your company has done something wrong, they would need to prove it. But in practice, in employment law, and many times, it comes down to the employer disproving the claim. And the best way to do that is if you have actually written out and agreed to a very clear understanding of not only the pay, but the details of the relationship between you and this contractor or you and the worker, the employee. That way, it's so much easier for you as an employer to protect yourself and to say, no, that was not the agreement. Here it is in writing. This is what we agreed to. This is the expectations were clear. And then you can kind of easily disperse any type of claim that is, without merit pretty easily.
I love that. So is this all wrapped beautifully into an employment contract or a contractor agreement? Where does all of this go? Or is it part of the offer letter? And actually, what's the difference between an offer letter and these agreements?
Yeah. So offer letter and employment agreement are often used interchangeably, but I think they are two very distinct documents.
Okay.
An offer letter, in the way that I use it in my practice, is only really useful in three scenarios. One, if you're trying to woo a candidate from a current job that they're in, and they're like, I'm not leaving this without something in writing saying what you're offering me and what I'll get when I get there.
Mm-hmm.
Two, if you are looking to do a background check or ask them to submit to a drug test, these both require authorization forms be signed. And so an offer letter is a great way to say, this is the basics of what we've agreed to, but this is conditional on you passing these tests. The authorization forms are included. Please sign and return.
Mm-hmm.
The last scenario in which an offer letter I think might be helpful is if you really want to make sure that they understand that they're going to have to sign an employment agreement that might contain something like a restrictive covenant, which would be like a non-compete or a non-solicit, because some states require that you give them advance notice. This is going to be required of you. Consider if you still want to take this offer.
Okay.
But the offer letter basically gives really high level info. This is the role we're looking at having you come into. This is what we're thinking of paying you. You're going to get benefits, blah, 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 blah. But, it's all conditional on X, Y, and Z. Whereas the employment agreement is the holy grail of documents, in my opinion. The type of employment agreement that I provide my clients with is a one-stop shop. You don't need to then have a separate confidentiality agreement, a separate NDA, a separate non-compete. I combine all of that into one easy document, so the expectations between the employer and the employee are crystal clear. I am a huge proponent of handbooks, and in some states it's actually required. But short of going into all the very, very nuanced detail that a handbook does, an employment agreement will address very important information that's related to the arrangement, such as who owns the intellectual property, what's considered confidential, and who does it belong to? Does the company pay you health benefits? Do they have a 401k? Are you allowed to moonlight? Can you work for another company while you're working for them? Do you have a post-employment non-compete or non-solicit? All of this, in my opinion, should be included in the employment agreement, so that if you never end up getting around to a handbook, which you still should, but if you don't get to it, at least you have this. So I often only use employment agreements unless, like I described before, it's one of those scenarios in which an offer letter makes a lot of sense. For contractors, again, it's just a contractor agreement. You don't give a contractor an offer letter that looks like you're offering them employment. And the contractor agreement, again, will outline the fees that they're receiving, what the company will and won't pay for. How do you terminate the agreement? And that's something I didn't mention, the employment agreement. Very important to discuss termination details. Do you get severance? Do you not? How many days do you need to provide them before you leave to leave in good standing? That type of thing. But yes, so the contractor agreement and the employment agreement are the holy grail documents, in my opinion, and are very, very important, because otherwise it's a he said, she said situation about, well, they said if I could get commissions, I got 10% commissions on everything. And the employer says, what? We said 10% on collected revenue specifically from this one area of the company. And you're saying that we told you 10% of the whole business revenue? And guess what the regulatory agency is going to do? They're going to side with the employee.
Oh, there's so much juiciness in that. And so what I'm hearing is cover letters. That's not a thing. Offer letters are less of a thing now, and you can kind of, just combine it all into this employment agreement, contractor agreement. Contractors obviously don't get an offer letter. But I love that you put everything in one, because I'm fractional COO for a company right now, and I was said, send me this stuff so I can review it, mostly so I make sure that they're not going to get in trouble too. And then he sent me 7 separate PDFs, and I was like,
exactly.
What is happening
it's so
here?
much harder for both the employee and the employer to keep track. And what happens a lot when you separate all of these documents is you only end up having the employee sign one or two, and then you miss 3 or 4 and 5. And I can't tell you how many times someone's looking to terminate, and I come in and say, okay, let's make sure we're doing this right. Give me their documentation. And they go, well, she signed the offer letter, but she didn't sign the employment agreement. And I think she signed her equity, grant, but she didn't sign the confidentiality document. And that's what happens. So if it's all together in one, you're covered, right?
You're covered.
And
yeah.
The other thing I will say with regards to that is I tell my clients to institute a very firm, hard rule that people do not start doing any work whatsoever until you have received the signed version of the employment agreement. Do not let them work for 2 to 3 months. Do not let them even work for a week, because in some states, if you have a non-compete in your employment agreement and they don't sign it at the very, very beginning of work, it becomes unenforceable. Yeah. And then you also run into like an issue where you give them some level of an argument about, well, I worked on that before I'd even signed anything, so that might not be your confidential information. That might be mine. It's not a great argument, but I've seen people try and say, well, I never signed that. So try to remember, if you're going to use an employment agreement, which I hope you do not let the employees start working until they've executed that document.
Yes. All right. So now has come the time for me to tell you this story of where we had hired a contractor to build a website. And of course, because Jenny is trusted friend and attorney, I said, hey, I need a contractor agreement for this gentleman. And it started out okay. And then things got really weird. Like, he was like, I need a document that has all the logins. And like, I'm like, but why? Like, we gave you like a company email to like single sign into everything. And he was just being really weird about it. And then we would have these planning meetings, and then the stuff we would get back was just, it had clearly gotten lost in translation. So, I mean, maybe this is going to get me in trouble by giving them an employee or a company email address, but I liked it because it gave me power over, like, once they left, we owned all the stuff. We didn't have to transfer anything. I also, in this case, could go into the back of G Suite and look at IPs, because things just started not to add up. And I'm like, this is just getting really weird. So I go in, and he's supposed to be in Florida, but then there's a series of logins from Bangladesh, from other areas of India. And so I talked to my other employee who's working on this project with me, and I'm like, what do we, like, this is weird. Like, and she's like, this is so weird. I've never encountered this before. I've worked with a lot of developers. She's my head of marketing. And I was like, I think we need to fire him. Like, obviously, like, something weird is happening. So before we had this conversation with David, I asked Jenny, I said, is my butt covered in this situation to let this guy go? And she said, yes. So we get on the phone or the Zoom call with this contractor, and I will never forget how it went down. He fully admitted that he was outsourcing the development work to other people in different countries. And my face, like, I wish I had a picture of my face, because I was just astonished, because I was like, I literally said to him, you do know that in your contractor agreement, it says you will do the work and that you will not outsource it. Like, these people have not been, like, they're not under our NDA. They're not under any of our employment agreements. They've not been background checked. We have very sensitive customer data that they now have access to. Like, buddy, what are you thinking? But then my favorite part of this story is he gets very sassy with me and very, very mad because he's been found out. And so we've obviously, during this point, me and Katie have tag teamed. So all of his access has been taken away while we're having this conversation and firing him. And then he says, well, I'm going to send you a final bill. I'm like, great. This is perfect. He sends me a bill for something like astronomical. And I'm just like, absolutely not. One, you didn't do this work. Number two, this is like highly inflated billing. So again, I went to Jenny and I said, what's our recourse here? And she said, well, what did you say? What do you think is fair? I think is what you asked me.
Something along those lines.
And I mean, at that moment, I was a little worked up, so I probably went a little lower than I could have. But she said, great. Okay, well, I'm going to write this letter. And it was, I wish I had it to read on the show, but it was the most like forcefully graceful, articulate, slap you in the face. Like clearly, like we are drawing a line in the sand, mister, of where you have violated section XYZ and are in breach of contract. And like Lauren's actually not obligated to pay you anything because you breached the contract, but as a sign of goodwill, she's going to give you X amount of dollars.
Yeah. That was an amazing. I mean, the gall.
Amazing.
The gall. But I see it all the time. And you were lucky that ended up resolving in a decent amount of time and without costing you too much money and heartache. But it did, take away time from you running your business.
Yeah.
And, it could have been way worse than it was. But you had an agreement with him. You had stuff in writing, which was very, very helpful. And that made it easier for me to defend you and to help you in the situation. So very, very important, especially anybody out there who has employees or contractors working on commissions. Let me tell you, commissions and bonuses are some of the most highly litigated points in employment law. People do not write these out. They don't write them out clearly. And they don't even know about some of the hidden landmines in the language that could really put your business in a really bad spot without having that clear language. So again, I cannot emphasize enough the importance of writing the agreement and making sure you are absolutely clear. Like think about that I don't know if everybody did this, but I think a lot of people probably did this when they were in elementary school. And you had to describe to your teacher how to make a peanut butter and jelly sandwich. Do you remember this? And people would be like, put the peanut butter on the bread. And so she'd just take the whole can of peanut butter and just stick it on the bread. She goes, okay, now what? That's kind of like you have to get into the nuance. You have to say, twist the lid off, stick a knife, holding one end of the knife, stick it in and get the peanut butter. That's how you have to write out your bonus and your commission language and your agreements with your workers, because it really does get down to the nitty gritty. I mean, there have been legal cases where everything came down to the placement of a comma.
Oh boy, that's crazy.
Dead serious.
Oh wow.
Yes.
That's a lot. And it's funny that you bring up the peanut butter analogy, because I feel like we're aging ourselves, but I brought this up last week when I was trying to explain the difference between an SOP that she downloaded off the internet to use as a template versus like how you actually have to write an SOP.
Yes.
So I love that. And I mean, I'm so excited that you came on the show today and just helped shed some light on this and like I said, demystify employment law, because like you've said a couple of times, there are so many landmines that we're not aware of that could really get us in trouble, even if we are well-meaning. And I think what I love most about, the contracts that we've put together, because you've done so many for me, is that it keeps honest people honest. Like, I think that's really what it's about. It's just everybody has a clear understanding. Everybody's on the same page. Everybody's got the same expectations. And like, God forbid, it goes sideways. Like you've got the law on your side in both situations.
Absolutely. Yeah.
Oh, wow. Okay. So before I wrap us up, because this has been so great. Do you guys see why she's such a powerhouse? And you want someone like her on your team. I mean, I could talk about this all day, but I am going to start wrapping us up. And I know we've covered a lot, but tell me, are there any last nuggets or pieces of advice that you want to share with our listeners that we didn't cover before we wrap up?
Yeah, I mean, I think if you're in an early stage or small business and you're hearing this and you're thinking, I cannot afford an employment attorney. I don't even know if I can afford to pay employment taxes. Like I said earlier in the podcast, you have to know what your risks are and then make it a priority that as soon as you can, pay for legal advice and or appropriate documents. It's worth your money. It's worth its weight in gold. Mm-hmm. Taking shortcuts early leaves you with a potential liability, a potential large liability down the line. So spend the money up front and you'll actually end up saving yourself a lot of money in the long run.
That is a great nugget. And I think what I found with working with you is it's an investment, but it's almost never as big of an investment as I thought it would be. So I worked myself up into a lather that it was going to be $10,000, but then it wasn't. And a lot of these things I can actually use over again, which is great. So you're investing in an independent contractor that then you can repurpose for contractors down the road or employment agreements. And so sure, maybe you spent that $3,000 up front, but then you don't have to spend it again.
Exactly.
And then you just have somebody that's on your team that can be don't do that. Oh, man. Okay, so tell our listeners, how can they further connect with you and the services of Vela Wood?
Absolutely. So we have a great website. We've actually won an award for this website.
Wow.
Yeah, it's www.velawood.com. And what's really great about it is that we have a resources tab. And under that tab, we have a very comprehensive blog that you just type in a keyword and you'll pull up a blog entry that we believe is very, very helpful and insightful. We try to give potential clients as much resources that we can that doesn't require them to pay money. And then from there, if you need a little bit more information, then you can reach out to us through the website. We also have a podcast. We have a couple of podcasts out there. I probably should know all of the names, but we've got a few. You probably just search Vela Wood and they'll all come up. But yeah, and if anybody listening has a specific question or wants to get in touch with me, you can reach me at jyoung@velawood.com.
Beautiful, beautiful. And you guys are a full service business law firm. It's not just employment law, it's all the things.
Absolutely. We've got specialists that do intellectual property, tax, M&A work, venture work, real estate, everything but litigation. We actually have a couple of attorneys who, including myself, I don't like to tell people this, but they have litigation background.
I saw that come out in the letter that she wrote.
So we have some strong litigation background here. We prefer not to take it all the way, but we're really good at pre-litigation, negotiating deals, and settling matters that could potentially go to litigation. So full service, and we've got somebody to help you with any question you might have.
It's true, and if for some reason you can't, you always know the person that I get to talk to actually make that work. So I love this. Well, this has been great. Thank you so much for coming on the show and just sharing all of this wisdom with our listeners.
Thank you so much for having me. It's been lovely.
Of course. Alrighty, everyone. That is it for this week's episode. Thanks so much for listening in. If anything we shared sparked something in you, we'd love to hear from you. So let's connect. Tag or DM me on Instagram at It's Lauren Goldstein or LinkedIn or wherever you hang out on the interwebs. Also, don't forget to subscribe so you're first to get notified when our next episode is live and ready for your ears. Thanks again for listening. Until next time. Thank you for listening to the Biz Doctor podcast. Now, I like to say that friends don't let friends WebMD your business. So if you're wondering what your next steps could be, here are some options for you. No matter what, head to the show notes or to my website, goldenkeypartnership.com, for some impactful resources to support you getting out from under your business. That's also where you'll find the links to learn more about our services and how we support business owners, just like you, who are ready to make the successful jump from business operator in the trenches to visionary business owner with more freedom and flexibility. All of that info is on our website, so pop on over to learn more or get in touch. goldenkeypartnership.com. Finally, if you love the Biz Doctor podcast, I'd be so grateful if you would share it with your friends and network and give us a 5-star rating or review wherever you listen to your podcast.
This is Story Studio Network.